Welcome to S&C's Critical Insights. I'm Annie Ostrager, a partner in the firm's litigation group and one of the co-heads of our employment law group. Today, Kamil Shields, my partner in DC, and I are going to kick off a Critical Insights series on a range of whistleblower developments impacting our clients. Sabrina Solow, an associate in our litigation group, will moderate today's discussion. We'll begin by providing a background framework for our discussion and describing the current landscape. We'll touch on the recent downward trend in SEC whistleblowing enforcement and contrast that against what we view as the opposite trend under other programs, in part driven by the administration's focus on whistleblowers as a potential means of pursuing its priorities. In subsequent episodes, partners from across our practice will join our series to focus on particular whistleblower developments and programs. Episode 2 will feature Kyle, Mack, and Kamil, and will focus on the Antitrust Division's new whistleblower program. Episode 3 will explore the DOJ's evolving corporate pilot program, the whistleblower program under the 2020 Anti-Money Laundering Act, and the False Claims Act QI-TAM provisions, which Nick Borton, the head of our Criminal Defense and Investigations group, will cover. And Episode 4 will analyze legislation introduced to protect and promote whistleblower disclosures regarding the development or use of artificial intelligence, which Mehdi Ansari, the co-head of our IP, technology, and AI practices, will lead. With that, Sabrina, I'll turn it over to you to get us started.
Thanks, Annie. I'm excited to be moderating this series. Kamil, can you start us off with some brief background?
I am happy to, and it's great to be here today with both of you to discuss this hot topic. And notably, it seems like almost every day there's some sort of new development from a federal agency related to whistleblower protections. So generally, what is whistleblowing? Whistleblowing means an individual who has original information, and that's critical, on suspected misconduct, and where that person has voluntarily come forward and, quote, tipped or provided a government agency with sufficient information relating to that misconduct to help the agency secure a resolution against the company that is at issue. In exchange for, quote, blowing the whistle, whistleblowers may financially be compensated through a percentage of whatever recovery is received from that company. Importantly, whistleblowers' identities are protected, and they must be, and this is required, protected from retaliation. Now, you notice I emphasized original. The information has to be original. That is, that the agency must not have already known that information, and that information has to be provided voluntarily. In the United States, there are a number, and this number is growing, of whistleblower regimes with slightly different eligibility requirements. And we're going to walk through those different eligibility requirements in a series. Now, we've already said that there are a number of federal agencies that have programs. These agencies include the SEC, the Fed, the CFTC, as well as a provision of the False Claims Act that has long provided a channel for whistleblowers to come forward. Most recently, DOJ Criminal and DOJ Antitrust have developed respective whistleblowing programs. While some of these programs are in their infancy, others have been evolving, and we will, as I said, dive into those programs in more detail in our later episodes.
Thanks, Kamil. Annie, what's the significance for employers of the availability of these different regimes?
So one takeaway is that a would-be whistleblower with original information may be able to proceed under multiple regimes. And each program, as Kamil mentioned, has slightly different requirements. So a whistleblower can go in one of several directions, depending on the subject matter of the information they think they have, the potential for recovery under the regime, and the eligibility requirements that Kamil alluded to, among other things. The other implication, of course, is that this may result in a situation in which a company is doing an internal investigation and someone gets ahead of them in terms of communications with the government, or that the framing of issues that are brought to the government is based on incomplete information or information that might be framed differently after a full internal investigation. And then, of course, the employment ramifications that Kamil also previewed, which protect whistleblowers from retaliation.
Interesting. It seems like these various regimes have created a complicated tapestry of considerations for companies.
Yes. For instance, the DOJ Criminal Division's corporate pilot program, which we'll talk more about in the series, may provide a path for a declination for a company should the whistleblower make both an internal report at the company and a submission to DOJ, and the company self-reports to DOJ within the prescribed time period, which is a short amount of time, 120 days, and then meets other requirements for a declination under the DOJ's policy. But that is not a straightforward path. As we know, the company may not know if the whistleblower has gone to the DOJ, and companies, of course, can't impede whistleblowing by requiring such a disclosure. And as a practical matter, it may be difficult to assess credibility and scope of a tip on that kind of time frame.
And Annie, it's interesting that you mentioned that 120 days because that's also part of the determinations in the antitrust program, the whistleblower program there. We'll provide a short preview of this and how I'll be excited to discuss this with Kyle. But the antitrust division has a slightly different approach to that 120 days. And what they appear to be really focused on is what constitutes original information. There are a number of carve-outs for individuals who do not receive original information. So that program is focused on what is the original information and when was it received by the company internally. Also, what is critical in determining what is original information for the program is when were relevant individuals made aware of whatever was the tip or whatever was the internal information, and what did they do in accordance with that. It's a pretty complicated structure. Kyle and I will discuss it during episode 2, so stay tuned.
Thanks, Kamil. In addition, potential whistleblowers may not be aware exactly of which laws or regulations are being violated, if any, but the number of programs and recent press attention might incentivize an increased volume of internal reporting, causing an increase in false alarms, and risk oversaturating existing methods or processes designed to investigate internal reports and determine which tips are credible.
Right. And the use of the press is another complication in this space for companies. And while that's not an avenue for procuring a whistleblower award, the risk that a would-be whistleblower makes allegations public by resorting to the press is something to be attuned to in the current environment.
Thanks, Annie. As previewed, we've been seeing an incredible amount of coverage on whistleblowing cases, regimes, and proposed legislation. But against this background of heightened attention to whistleblower activities, we're seeing a downturn in SEC awards. Kamil, can you give us some background on this?
Definitely. Thanks, Sabrina. So notably, the SEC's whistleblower regime is fairly well established. It was enacted through the Dodd-Frank Act in 2010 in response to the financial crisis and some high-profile enforcement failures. And this program is designed to encourage individuals to report securities violations directly to the SEC by offering financial incentives and confidentiality to that individual. To be eligible for a financial reward under the SEC's whistleblowing program, the whistleblower has to voluntarily provide original information that leads to a successful monetary sanction against the company exceeding $1 million. And these kinds of awards range from 10 to 30% of the collected recovery from the company. And as Annie mentioned, in the context of other programs, the whistleblower's confidentiality has to be protected. In 2024, the top whistleblower award under the SEC's program was $98 million awarded to 2 whistleblowers. So that's some pretty serious money that's at stake.
Yes, that's true, Kamil. But as we mentioned and has been reported in the past couple of weeks, the SEC has denied over 30 consecutive orders this year between late April and mid-July. And in fact, only about $20 million has been awarded this year. Although we're only a little more than halfway through the year, that is a significant decline from last year when the agency awarded over $255 million to 47 individual whistleblowers. And that could reflect a change in approach and priorities at the SEC. One possible manifestation of this, which we've talked about before, is that under the last administration, we saw a significant uptick in SEC enforcement actions related to the Whistleblower Protection Rule 21F17. That rule provides that no person can take any action to impede an individual from communicating directly with the SEC about a possible securities law violation, including enforcing or threatening to enforce a confidentiality agreement with respect to such communications. And the CFTC has a similar rule. The SEC rule was passed in 2011, but really saw very little enforcement, nothing until 2015. But then starting in 2023, we saw a significant increase of activity here with a number of enforcement actions and a cumulative civil monetary penalty of over $45 million. And we saw that the SEC was seeking to apply this rule in a wide variety of contexts and investigating and asking for the production of employment agreements, settlement agreements, policies, NDAs, all kinds of other documents from companies, and taking a very broad reading of Rule 21F17. Under this administration, however, we've not seen any standalone enforcement actions related to Rule 21F17.
Thanks, Annie. This is definitely something we'll continue to monitor. Kamil, you mentioned earlier the importance that a tip is original information. Can you discuss the original source rule guidance?
Yes, and obviously this is really critical for any agency with respect to what is original information, who's the original source of the information. So this past May, the SEC published an order in which it claimed there was flawed reasoning behind a 2022 award that had been distributed under the prior administration, the Biden administration. In the 2022 award, the SEC had granted an award to a claimant who had first published his report online with original information on certain misconduct. That report was then found by the SEC and prompted investigation before the individual had actually emailed the report to the enforcement staff. The SEC at the time reasoned that the whistleblower was still the original source of the content in the online report, and that is what had ultimately caused the SEC to open the investigation. Although the SEC had been aware of the information through the online report before that individual had actually reached out to the SEC, directly contacted the SEC with the information. Because the SEC determined that this individual was the original source, the whistleblower earned an award. And then there was a dispute that really was raised in the Third Circuit between the first whistleblower and a second whistleblower who had been denied an award. Without getting into the weeds, the Third Circuit questioned how the first claimant's tip had significantly contributed to the success of the action when the investigation began, when the SEC found that online report on its own. So it hadn't been a result of the whistleblower contacting the SEC. Now, in this most recent May 2025 order, the current SEC clarified that it will construe original information more strictly than the SEC had in the past by adopting a, quote, submission-focused interpretation over the 2022's information-focused approach.
Thanks, Kamil. And as one last preview for what's to come in this series, I'll just say before I turn it over to Sabrina to wrap up that one area where we think we'll see increased activity in the whistleblowing space and from relators in key TAM actions and generally here relates to potential false claims investigations and litigations in the DEI space. And we know from what we're seeing already that this will be something that companies have to confront and that it's a priority of the administration. So we'll cover that in more detail in a future episode.
Thanks so much, both. It was great to talk to you today about this interesting topic. We've now set the stage for our series addressing whistleblower developments, which we hope you'll tune in for. So let's conclude our first episode. Thank you for listening to S&C Critical Insights. For more information about our practice, please visit us on the web at www.silcrom.com.